Good afternoon, everyone, and welcome to today's session on rewarding employees. My name's Andrew Yarl, and I'm a Senior Associate in the Workplace Law and Culture team at Bardia Perry. Originally, James Matson, a partner in the team, was to be presenting today, but he unfortunately has not been able to do so, and he sends his apologies. I'm also joined today by Eric Kwan, who's a Senior Associate in our Corporate and Commercial team. And to begin, I'd like to first acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land from which I'm speaking today, and we pay our respects to the elders past, present and emerging. And so firstly, for just some housekeeping for today's seminar. So you'll have the opportunity to ask some questions at any point during the webinar by typing your questions into the control panel box, and we'll endeavour to answer your questions at the end of our presentation. You'll also receive a copy of the slides and the recording post-event. And we'd appreciate if you could also take the time to fill out a short survey if you can take a moment at the conclusion of our presentation. And if anyone has any sound issues during the webinar, I'm told you can look at the handout for assistance, which is in the side control panel where you type in your comments, or you can reach out to us via email or in the comment function if you have any issues. So now to the substance of the presentation. So today I'll be speaking about common rewards for work, and my presentation today will really be focusing primarily on those last 2 points there, so 3 and 4. However, the common rewards for work include remuneration, of course, which can arise or does arise under contract, or industrial instrument, for example, an enterprise agreement or award. Allowances and benefits, which can also include non-financial components like access to motor vehicles, or even access to gym facilities, wellness programs, and those type of benefits, as well as bonuses, which can be paid periodically, like yearly short-term incentives or long-term incentives. And they can often be linked to matters within the employee's control. For example, their own KPIs or other certain targets that are notified to them. Or also it can be linked to something outside their control to some degree. For example, overall organizational performance. It can also, and often is the case, it can be a combination of the two of those types of targets. And then you'll see there too, we'll speak about commissions, which are fairly common, particularly in the sales industry. So the most common type of reward is remuneration, and that, of course, an employee expects to be paid for their work. And it's also important to the legal deal being struck between the parties, being the employer and the employee, because a contract requires consideration to be enforceable. And as you all would probably know, that requires something to be given up on both sides, or a commitment from both sides to be operative and enforceable. And as I said before, remuneration can also be included in industrial instruments, which we always say should not be contractually incorporated, and there can be a express clause in the employment contract in that regard. And of course, the employment contract cannot undermine the industrial instrument minimums. So with respect to contractual matters, they must be observed by the employer and of course the employee as well, because there's obligations on both sides. Today, of course, we're focusing on the employer. And if they're not followed, there could be a breach of contract claim, which could lead to damages and could have impact on post-employment restraints. So for example, if an employer unilaterally reduced a contractual entitlement, the employee could claim that the employer has repudiated the contract. The employee could then elect to accept that repudiation, and that would impact on the ability to enforce post-employment restraints, which are often a very important and valuable clause to be enforced after termination of the employment relationship. And then with respect to today's topic, as employment lawyers, our team primarily assists employers, and we would always recommend that a bonus or incentive scheme is discretionary and in policy if possible. But we do appreciate that depending on the industry you work in, the purpose of the scheme and employee expectations, which are dictated by those two things as well. It might be that as an organisation you would like to make it contractual. So if you look at the reasons that an employer might offer bonuses and commissions, there might be a number of reasons. As I say, it might be the industry you operate in. For example, if you're in a sales role, it's very, very common to have that incentive. Or it might be to make an offer more attractive to staff, particularly in a tight labour market that we're currently in as well. It might be to incentivise employees to work harder because they're getting a benefit directly for their effort, or it could be a combination of those reasons. So as I say, it would be our recommendation that if possible and if it aligns with your business model and market, that bonuses be covered by a policy. But it is possible too that even if it is in policy, it could be found to be contractually binding in certain circumstances. And that would be by way of incorporation. So the general principle is that a contract of employment incorporates as part of its express terms external materials like policies, when a reasonable person would think the policy was intended to be contractually binding, or put in another way, it depends on the party's intentions and what as objectively determined from the circumstances. And so of course those circumstances will differ depending on the specific factual scenario at play. But two important factors might include the language which the document is referred to by the parties in the employment contract, and the document being the policy's nature and subject matter. A policy would be more likely to be found to be incorporated if the language in which the parties refer to it reflects an intention to offer and accept mutual obligations. And it's important too if the external document has specific benefits rather than imprecise or high-level comments or statements in it. And other relevant factors might also include whether the policy was provided or made available at the time of the offer of employment, whether the employee was required to provide some acknowledgement that they'd read it and agree to the policy document or other external document, and whether the external document conferred a benefit of a kind ordinarily found in contracts. But with respect to incorporation, you can have express exclusion in an employment contract that policies do not form part of the contract, and that's quite common. And that will be observed. And that, as I say, that's preferable, but it depends on your organisation and your industry. So you see that case there referred to Farrell and Choosewell Health Link Limited. That case concerned a commissions claim by a former employee. And there are a number of issues at play in that matter, but we'll obviously focus on the commission claim. And the contract in that case provided if you are required to comply with all of the employer's policies and procedures as instructed or amended by the employer from time to time, whilst applying to you, the policies and guidelines are not incorporated into this contract and do not create enforceable contractual rights for you. So looking at the circumstances in that case, in particular the contractual clause, the court concluded that it was objectively clear that the applicant's employment contract did not include the employer's policies by reason of the clear wording that I just read out. So it is possible and quite common to exclude it expressly. And I should also say, if it is excluded from a contractual application, then it's not the employee is limited in suing in relation to it, which that employee was in that case. For example, they were suing saying that they are entitled to a commission, and the court said, well, it's not contractually binding. So now we'll turn to the important consideration for an organisation of what the purpose of the policy is. The policy of the reward scheme is, sorry. As this could impact on how it's interpreted to apply if an employee makes a claim, or it may influence how the business wants to offer the reward scheme, whether that be in policy or contract. And therefore it can be a more cultural or business consideration on the expectations of the market. And so there may be a number of purposes to consider as part of any reward scheme. Firstly, it could be that it forms part of remuneration. So for example, a sales employee, they might have the vast majority of their take-home pay is from commissions, and their base salary is only a small proportion of their overall take-home pay. And therefore, it could be more akin to remuneration in that situation. And therefore, could it be more likely to be contractual than not, or would that be the expectation? Or it could be that the incentive scheme is to drive performance, and then enforceability in that case will turn on how it's described and the intention of the parties, etc., which I was just touching on. And it might be in that case that inclusion in just a policy without incorporating into the contract is preferable. And then maybe the purpose is to keep up with industry expectations, or perhaps it's to retain and attract the best staff, or instill commitment to the business. And in that case, then perhaps the business will make the decision that including it in policy, not in contract, is the best way forward for your business. So generally, as I said above, it'll be in the employer's best interest to have the scheme as entirely discretionary, but we think it's important to kind of look beyond the words of a contract sometimes as to what courts have found with respect to contracts which say it is entirely discretionary. So we'll turn to this case here, Silverbrook Research Pty Limited and Lindley, in the New South Wales Court of Appeal. So the clause that was in dispute in this case was the employee will be eligible to receive the bonus subject to clauses 4.2 and 4.3. 4.2 provided that the employer will assess the employee's performance against set objectives at the end of each quarter, commencing from the date of her employment, provided her performance satisfies the set objectives and subject to clause 4.3, which I'll come to. 1/4 of the bonus will be paid to the employee within 21 days of the end of each quarter. 4.3 provided the decision as to whether the employee should receive the bonus is entirely within the discretion of the employer. The employee must be still employed by the employer at the time the bonuses are determined to be eligible. So the claim from the employee in effect was that the employer had breached this commission scheme in a number of respects. The court found that in the contract, the employer had promised that it would establish a set of objectives at the end of each quarter. It would assess the employee's performance against those objectives, and subject to its discretion, if the set objectives were satisfied, the bonus would be paid. But importantly, it wasn't a promise to pay the bonus. The employee was promised that there would be the setting up and undertaking of this process of assessment of performance with the contractual opportunity or chance of obtaining bonuses should the results of the process be favourable, and then subject to the exercise of the discretion. So in exercising that discretion, while the terms of the contract said the bonus is entirely within the discretion of the employer, the court said, well, that can be said on the face, but it can't be withheld capriciously, arbitrarily, or unreasonably, and basically that the discretion must be understood in the context of the contract. And then the court also went on to say that it must be exercised honestly and consistently within the purposes of the contract. So then if we think about that for a moment and going back to what I was discussing before, considering what the purpose of the reward scheme is, if you think, for example, if the purpose of a reward scheme is to keep an employee devoted to the business and productive, but the employee is in their notice period when the assessment's being done or the payment's coming up, and this is a discretionary contractual reward scheme, would it be unreasonable to withhold the discretionary bonus in those circumstances? Well, if the purpose is to keep them devoted to the business and that is expressed as the intention, then perhaps it wouldn't be in that situation because the employee's on their way out, basically. But then if you think too about a discretionary contractual reward scheme where it's intended to reward an employee for their effort in making sales, for example, then if they've already made the sales, then would it be capricious, arbitrary, or unreasonable to withhold the discretionary bonus from them, even if they're in a notice period? And then possibly it would be unreasonable because the purpose of the scheme is to reward them for making the sales, which they've already done. And as I've been touching on, it ultimately depends on the scheme wording and the circumstances in the specific situation. So now I'll move on to another matter in the Fair Work Commission, Bozina and Tweed Coast Auto Group. In this case related, This case related to a jurisdictional issue raised by the employer in relation to a general protections application made by the employee. And there are a number of arguments, just like in the previous matter, but we'll focus obviously on the findings in relation to the commission scheme for today's presentation. So just by way of background, the applicant was employed as a business manager on a base salary plus commissions and had some benefits, had a motor vehicle as a benefit as well. The commission clause provided that the employee was eligible to participate in the commission scheme, but commission payments were discretionary, and that the scheme provided no guarantee that the employee would receive any payment or incentive. And the contract attached the commission structure as well, which is obviously relevant in such cases because of it being provided to the employee at the time of the offer. And then the employer appointed a second business manager to a position that was broadly equivalent to the employee's role, and therefore there were two, and that limited the pool of commissions available to both of them. The submission of the applicant in this case was that the appointment of the second business manager was in breach of his contract because it would reduce his access to that income, but that was rejected by the commission on a number of bases. Firstly, it was found that whilst the contractual term between the parties was that the employee was eligible to participate in the scheme, and whilst commissions were an element of his overall REM package, the contract expressly provided that the commission income was payable at the sole discretion of the employer. The employee was contractually eligible to participate in the scheme, but not contractually guaranteed of any level of commission income, even though he had a reasonable expectation that he would receive some income, some commission income, that is. The commission went on to say that even if it was a contractual term, that the commission income, according to the structure, was to be paid to the employee. The employer did not alter the employee's eligibility for the commission structure itself, and there was nothing in the contract that said that the employee was to be the sole officer in that position, and therefore be the sole person with access to that commission structure. So that case is helpful because the commission obviously focused on the term, the sole discretion, as well as looking at the overall circumstances, giving the employer flexibility. Although that discretion would need to be considered in light of the previous decision in Silverbrook that I discussed with respect to the exercise of that discretion. And you may have also noticed there was really only a slight variation in the clauses in Silverbrook and the terms of the commission clause in this case. And there were different arguments mounted by the applicants in both cases. So in this case, the applicant claimed that the appointment of the additional business manager was a breach of his contract, whereas in Silverbrook, the claim was that the actual terms of the incentive scheme were breached with respect to the assessment, the setting of objectives, etc. And they're also in quite different jurisdictions, so the Fair Work Commission versus the New South Wales Court of Appeal, which can have an impact. And also, I think it's important to note that in the Bozina, that there was the express clause, there is no guarantee that you'll receive any payment or incentive, which is quite clear on its face as well. It's not clear whether that was a decisive determining factor for Bozina though. So as I've said a number of times now, we'd always recommend that it's an incentive or bonus scheme is in a policy and provides the employer with maximum discretion and ability to amend or remove or decide how best to reward its employees moving forward. However, again, we appreciate that that might not be everyone's preference because it might not attract the best staff or keep them, and that a discretionary no obligations policy outside contract would just not be appropriate in your industry. And so we thought we might just outline some helpful considerations here with respect to a scheme, whether it's in policy or contract. So the starting position, just have a think about what the purpose is of the scheme. Is it part of the standard remuneration in your industry? Would that be the expectation? Or is it to drive performance or loyalty? Or is there some other purpose or some combined purpose of those two? And then depending on that purpose, it might change how you want to manage it, whether it's in policy or contract. And then you can consider whether an employee will just be eligible or will they be entitled. So if they're eligible, they may participate in the scheme, for example. They're eligible to participate. And then logically, they may not be entitled to receive a payment from time to time, depending on the circumstances and the terms of the scheme. Or is that too uncertain and entitlement should be guaranteed if certain criteria are met? And if so, what are the criteria and how best does it fit in with your business model and how you reward your employees? And then that leads to, of course, whether it's contractual or not. So if it's a term of the contract, it might be most appropriate for your business, but if that's the case, then it's important to think carefully about the terms of that scheme because they will have to be observed for risk of a damages claim, breach of contract claim, and other implications like with respect to post-employment restraints, as I outlined previously. Or if it's only in policy, and if that's the intention, then careful drafting too needs to be in the employment contracts to ensure that the intention is maintained. And if only mentioned in policy and not incorporated into the contract, and depending on the flexibility afforded by the policy, there might be organisational considerations moving forward as to its implementation from time to time, whether to amend it in the future, whether to withhold reward payments in certain years and other considerations. And then leading on from that, do you as an employer want the absolute and sole discretion? Is that appropriate in your business model? And it will allow you flexibility in different circumstances, but how is that best achieved in light of what I was discussing about exercise of that discretion if it's incorporated in contract, for example? And will you say that payment's not guaranteed, like in the Bazina case? And what does the contract say in that regard if it is contractual? Then with respect to quantum matters, and this goes to the terms of how the calculation of the scheme. For example, is the reward calculated or paid on a sales made or when payment is received from the client? So that's an example of a balancing act between, does the business think that the employee should bear the risk of the client not paying for the services they've rendered? Or is the reward for the employee's performance as opposed to the risk of a bad debt? And should that bad debt risk be carried by the business and not the employee? And those are just considerations that for the organisation to understand. And then consideration needs to be given to how clear and measurable other KPIs are aside from financials. Financials are often quite easy to quantify. But for example, it might be adhering to the company's values is one of the qualifying terms. And how is that assessed? Who assesses it? And it's just something to consider to avoid disputation with employees. And even if it's only in policy, it can just cause general discontentment within your workforce if someone argues with you and says, well, I did adhere to the company values, and you say, well, no, you didn't. So that's something to be considered. And then leading on from that, qualifying terms. So this is again for the business to consider. What's the essential components for participation? Are there gateways to be met? For example, it's often the case that only employees who successfully pass their probation period will be entitled. And that might go to the purpose of rewarding loyalty or longevity of the employment relationship. Then leading on from qualifying terms, are there any disqualifying terms? So does the employee need to be employed at the time of payment, which is quite common? For example, if the scheme's to reward loyalty, then it's logical that they would be. And as I mentioned before, if it's more akin to remuneration, then perhaps it's less important. And then, for example, a common disqualifying term is that you're not subject to investigation for misconduct, you're not undergoing performance management or any other misconduct process. So that's, I suppose, rewarding a good employee. And then we need to think about what happens on termination. Is it different if an employee is redundant, is being made redundant and they're in their notice period versus an employee who's resigned? Are there good leave or bad leaver provisions? So if someone leaves under a cloud versus someone who resigns, and otherwise the employer is happy with their employment. And are there any prorated payments for length of service or achievement of certain goals? And then the last one is the ability to vary, which does obviously relate to some of the other, I suppose, considerations I've outlined there, for example, discretion, etc. So can the employer vary or terminate the scheme as it sees fit? Does the employer need to consult or obtain employee agreement? So that will be, well, if it's in contract, then of course the employee's agreement will be required. If it's in policy with discretion permitted, then it might just be a cultural consideration to keep your employees happy. So now that's the end of my section. I might just look at, before I pass over to Eric, have a look at some questions, if there's any questions that have come through. There's no questions as yet, but if there are any questions, there'll be time at the end as well, and we're able to also answer questions following the seminar too. So I might hand over to Eric now.
Thanks for that. So I guess to build on what Andrew has talked about already, I'd like to focus on one specific tool that you may want to deploy as part of your remuneration strategies, namely an employee share option plan or employee share scheme. In particular, I'll be focusing on what they are, why you may want to implement one, and what you should be aware of or have at the back of your mind if you do decide to implement one. Now, feel free to type questions into the chat box as you go. However, we'll be responding to them at the end of the session. Okay, so I guess, what is an employee share option plan or ESOP? As a lawyer, I tend to see what the law says. However, there are actually two definitions available, one taken from the Corporations Act and the other from the Income Tax Act. Now, without boring you too much on why we have two definitions, the common theme is that an ESOP is a scheme or plan under which employees can take up shares in their employer companies. What this means, though, is that things like phantom share schemes and employee remuneration trusts, which don't really involve issuing actual shares, as well as those one-off share issues or options, aren't really captured or caught by these definitions of ESOPs. This does have some significance when we go to talk more about compliance issues. However, I don't really want to touch on these types of deals or transactions in any great detail, but if you are looking at one of these types of programs, I'd be more than happy to have a chat with you offline about them, as they are, once again, quite useful tools to have in the strategy to incentivize the staff. Okay, so I'm not sure what's going on there. Okay, I guess, so moving on to the question as to why you may want an ESOP. Now, I guess there are plenty of reasons out there why you as a business owner might consider adopting an ESOP. However, I might only touch on the main few that come top of mind. So top of the list is really the fact that an ESOP allows you to, I guess, tap into the equity of a business, and means that you don't have to actually pay cash to employees. This can be especially important when you don't have that much free cash hanging around. And it is also one of the main reasons why a lot of startup companies decide to deploy ESOPs, mainly because they're trying to effectively bootstrap their way as far as possible before they look out for, say, private equity or float or some other form of investment. Now, on this point, one of the more publicized examples out there is really for Facebook. Back in those days, those very early days, Facebook didn't really have any revenues to speak of. So Zuckerberg and the fans over there thought it best to really issue stock to attract and keep those quality staff that they have. Things have obviously changed quite significantly since then, and their ESOP has evolved as well. Now, another reason why you might want to consider an ESOP is more from a human resource management point of view, which is what Andrew's touched on, in that really making an employee a shareholder really instantly aligns those interests together. There is also a line of thought that employees who put their own money on the line become more invested or effectively have skin in the game, so to speak. Additionally, with the ESOPs, you can attach things like vesting conditions, which are essentially conditions that need to be satisfied before the employee themselves becomes entitled to the shares. And I guess in relation to options, conditions that need to be met in order to have the privilege of exercising the options for the shares. Now, the usual conditions I find clients have are really designed to ensure the employee sticks around, but you can be a bit more creative around this. On the point of, I guess, alignment and goal setting, one of the findings from the Royal Commission into misconduct in the banking, superannuation, and financial services industry a few years ago was that, at least in the banking sector, there was a general culture there of encouraging a short-term focus, as a lot of the staff bonuses were aligned to the achievement of short-term performance targets. Now, ESOPs aren't exactly a recommendation from the Royal Commission, but they are a good way to make sure that the employees themselves think about long-term sustainability, mainly because at that stage, they do become part of the shareholder body, which means they look at the long-term value of the company. The second thing is that you can easily attach those medium to long-term KPIs to the ESOPs. And finally, in most cases, ESOP participation doesn't actually bear much fruit until later down the track. Now, a further reason you may want to consider implementing an ESOP is if you, as the, say, principal business owner, are really looking or considering stepping down eventually, but you don't really want to do so suddenly, which is effectively what's happening with a lot of my clients at the moment. ESOPs for these people can be quite attractive or useful when there is an existing talent pool or emerging leadership team within the business itself. And you have a group of people that really want to try and step up, but may not actually have the cash to do so. Having an ESOP in place in this sort of scenario is great because it does allow you as the business owner to show those senior employees and I guess potential employees that there is a clear pathway upwards, and that those employees don't really have to leave the business in order to achieve that. Another reason is that it can secure the employees for the long haul, mainly because at that stage they become part business owners. And then I guess if they'd be reluctant to leave the business at that stage. Another thing is that it gives those senior employees generally some comfort that you will at least be sticking around for at least a few years, rather than, say, go off and wind up the company or sell the company or I guess just retire full stop. Another reason, I guess, that you might want to consider an ESOP in those sort of circumstances is that ESOPs generally can be designed in a way that doesn't require an employee to invest or put money or large sums of money into the business straight up. This is mainly because ESOPs can be designed so that, say, you can fund the ESOP or the acquisition of the shares through, say, company loans or, I guess, just a dividend set off, rather than go off and have the employees dip into their own personal life savings or take out bank loans. This sort of elemental thinking is really key, or usually top of mind for people that are or employees that have younger families that they're raising. Now, whilst an ESOP by itself won't be enough to implement the full transition or handoff, it does pave the way for this to happen, especially when you couple it with a good shareholders agreement. Okay, so I guess another reason for considering an ESOP over another form of remuneration is the fact that employees generally get more out of shares or capital rather than cash. This is, I guess, particularly important when the employee is already receiving a fairly high salary to begin with, and giving them more just means that they are paying the taxman more, rather than actually offering them too much more of an incentive. Yes, I'm being a bit cynical, but I think employees generally do realize that there is a correlation between tax and remuneration, especially when with those people that are always budgeting all the time or quite aware of what their personal finances are. Okay, so hopefully I've sold you on why you may want an ESOP, but I guess so that you have a more balanced picture, there are certain reasons why an ESOP might not be such a good fit. And those reasons usually are that the business itself isn't structured in a way that can issue shares or options, which is, I guess, normal situation with say a business trust. You may also have certain authorities or licenses that make it quite complicated or difficult for you to get appropriate authorities to do so. So say, for example, manufacturing licenses with the Therapeutic Goods Association or registered training organisations with the Australian Skills Quality Authority. And I guess the final reason, or the other main reason, is that you're looking to sell anyway. So I guess putting one in place just to wind it up down the track doesn't really make too much sense. But having said all that, it doesn't mean that ESOPs themselves are a bad idea. It just means that there may be other tools that are going to be more effective in the circumstance. Now, I guess moving on, so we've talked about what ESOPs generally are and why you may want an ESOP in the first place. But to give you a better feel as to what an ESOP might look like, I'll want to talk about what types of ESOPs there are. And I guess in talking about types, it's best to look at things from a tax perspective, even though I'm not a tax lawyer or accountant. Okay, so in this regard, we do generally categorize ESOPs into two parts. First part is the non-concessional, or the ESOPs where there are no tax concessions available. And the second part where they're called concessional ESOPs, or I guess where employees can potentially access tax concessions. This concept really feeds into the comment I had before about employees preferring, I guess, ESOP interests or shares over actual cash bonuses. Moving on with the concessional ESOPs, there are generally three types of ESOPs or concessions available, namely an ESOP where you are taxed upfront, one where the tax is deferred, and the final one which applies to startups. Okay, so I guess to explain each of these, it's probably best to start with how ESOPs are treated generally when you don't meet the requirements for one of those concessional ESOPs. So I guess if you look on your screens, you can see a brief timeline there of the trigger points, or what are called taxing points if you want to use the lingo. The slide itself should be pretty self-explanatory, but briefly, for the employees themselves, you can see that they need to be accounting for any value that they're receiving as part of their income tax. So I guess if they are, say, receiving shares for free, then they account for the full value of their shares as part of income tax. And then I guess down the track when they go and sell and make a bit of money off the shares, they will have to pay CGT on them. Flip side, for the employers, they effectively note the value that they give as part of the remuneration paid as part of reporting, and then subsequently they pay the payroll tax when those shares vest, or I guess when the conditions are met and the employees get entitled to the shares themselves. Okay, so that's the non-concessional. Moving on to the concessional. Now, this is, you can see for taxed upfront schemes, is largely the same as where you don't have concession applicable, but rather than being taxed at full rate at income tax, the employee does get a $1,000 tax reduction. This can be very useful when we are talking about shares that aren't exactly worth huge amounts anyway. So for example, those startup companies we were talking about. Okay, so moving on from that, we look at the tax deferred schemes. Things change slightly here in that everything that was originally dealt with as part of the invitation and grant, and then subsequently with vesting, now happen at issue of vesting, or I guess to be more accurate, or using the lingo again, where there is no real risk of forfeiture and there are genuinely no restrictions on the disposal of those shares. Practically speaking, what this means is that the employers don't really report or pay payroll tax, and employees don't get assessed for income tax until this particular point in time. There are, I guess, some few interpretation nuances about what this all means, but I don't intend to really go into this in huge detail. And I guess at the bottom there you can see CGT is still taxed on disposal. Now, moving on to ESOPs for startups, or concessionals for startups. Now, this is probably where the biggest change is for at least the employees, in that the employee doesn't really account for income tax at all in these sort of circumstances. CGT is still payable on exit as usual, and I guess from the employer's point of view, things don't really change at all. Okay, now there are, I guess, certain requirements around ESOPs and complying for those concessions, which are, I guess, primarily for the employee's benefit, and they're, I guess, ultimately designed to help lower the cost of barriers for employees to participate in an ESOP in the first place. Now, as you can see on the screen, there are certain criteria that need to be met in order to comply or meet these individual concessions. But I guess without going through those in huge detail, the underlying theme is that you need to be issuing ordinary shares. The employees themselves can't be holding more than 10% after all those shares have been issued. And there need to be certain restrictions in play which effectively prevent employees from cashing out within the first 3 years. There are also a few fiddly bits in order to come within the requirements for each of these concessions, but I guess we're going into more technical detail here. Happy to, I guess, chat offline later down the track if you do want some more information about these, but these sort of things can be easily Googled, or you can look these up on the website. Moving on to compliance, but to briefly recap on things though, an ESOP generally involves the issue of shares to employees, so it's a useful tool for remunerating and incentivizing staff. And there are certain tax concessions available to employees in relation to ESOPs that make them more attractive or accessible, assuming those criteria are met. But there are, I guess, a few compliance-related issues that you need to be thinking in the midst of things. Top of mind, I guess, as a corporate and commercial lawyer, is the need, or the fact that you need to comply with the Corporations Act, mainly around those fundraising disclosure requirements and financial services regulations, mainly because we are talking about a scheme for financial products that you are potentially selling or collecting money from employees for. in the broad, those sort of things require or involve you making certain disclosures about the scheme, and that usually takes the form of a prospectus document or a disclosure statement, and having an Australian Financial Services license or an AFSL. Having said all that though, a lot of it, or at least the regulation, can be short-circuited if certain requirements are met, and these sort of requirements are now prescribed in the legislation, which it came through on 1 October 22. I won't really labour over these, but in very simple terms, you now access that regulatory relief from full compliance with those fundraising disclosure and financial services regulations, as long as the ESOP itself meets certain content and structural requirements. And if you comply with the relevant issue and monetary caps and make the requisite disclosures as and when required, there are potential, civil offences for not complying or failing to meet those requirements, as well as the usual criminal offences for making misleading and deceptive statements in those disclosure materials. However, on the whole, ASIC doesn't really normally ask for the relevant documents to check as a matter of course. Some companies, though, are obliged to file. So, for example, those listed companies. Talking about listed companies, there are, especially those that are listed on the ASX, they do need to comply with the ASX listing rules, primarily in relation to the continuous disclosure obligations and the related party dealings. I won't really dwell on this, since I don't think most of you are looking to be implementing ESOPs for a listed company, but just be aware that if you are, that you do need to get certain shareholder approvals for the issue of those shares, and for the ESOP itself. Now, the other thing from a compliance perspective is around tax, or I guess more importantly, around valuations and reporting for tax. Valuations themselves are actually quite important for ESOPs, namely because you need to know the value of the shares that are being issued, so that you can assess what the value is and whether it's worthwhile issuing them. And then on the flip side, if you're an employee, then the employee needs to know what tax to pay on them at the end of the day. They're also quite useful, I guess, from the perspective that you need to that you may need to comply with the monetary caps or the issue caps, and to make the disclosures out of the regulatory relief. Now, I guess the topic of valuations itself, I try and leave with the accountants, mainly because they're the pros at that sort of thing. But just, I guess, so that you know, the ATO has published certain rules or guidance around the conduct of valuations, which can, or usually does, take you away from the usual concepts around, say, fair value or market value, which is, I guess, quite important from the perspective of the disclosures and tax. In terms of reporting, this can generally be split into, I guess, reporting to the employees, which is largely consistent with the disclosure requirements under the Corps Act, and then reporting to the ATO itself about what ESOP interests you've issued during the year. Once again, I won't go into this in huge detail, mainly because of timing, but I do suggest you speak with an accountant when you go about establishing an ESOP. Other than, I guess, compliance, there are a few other issues that you do need to be wary of when you go about designing and implementing an ESOP. The first on the list is director's duties, mainly because, I guess, as part of the disclosures, you do need to be giving a solvency statement. And then, I guess, if you are a director and you do or can potentially participate as a potential recipient of those ESOP shares, then I guess you may have a conflict of interest in those sort of circumstances. The second thing is around funding, or really more around how you're expecting employees to fund the acquisition of shares. I guess as I alluded to before, there are a few potential ways this can happen, such as through company loans or dividend set-off or something along those lines. And this can feed into what you need to be disclosing or be providing to the employees themselves. The next on the list is with the Constitution, or I guess more specifically, what is allowed under the Constitution and how you actually go about implementing or approving an employee share scheme or option plan. And then the next one there, the shareholders agreement, similar logic in terms of procedural and making sure you have the relevant approvals for it. But once again, and as I mentioned before, if you are potentially looking at using the ESOP as part of an exit strategy, you need to make sure that those exit mechanisms are actually there. Just a, I guess, point or a note there, if you do have a shareholders agreement already in place, you need to really reflect on whether the contents of that shareholders agreement is really still applicable given the potential increase in shareholder numbers and shares on issue. And I guess that goes and has input or influences decision making and board mechanics. And I guess on the flip side, if you don't have one, then it's probably a good time at that stage to implement a shareholders agreement. Now, I guess the final issue I wanted to touch on is really in relation to privacy or personal privacy. As I mentioned before, the company does need to make certain disclosures and file certain reports as part of implementing an ESOP. And this sometimes involves personal information or information about employees. Having said that, it does usually pay to make sure that you have any relevant or requisite consents in place ahead of time. So employee agreements usually covers that off, but you can easily build that sort of thing into an ESOP itself. Now, I guess to recap on today's session, now Andrew has spoken about employee remuneration and bonuses generally, as well as gone into a bit of detail about what you should be thinking about or be looking out for when you go about designing these remuneration and bonus strategies. And then I guess building on this, my focus today has really been on the employee share option plans and schemes, in particular focusing on what they are, why you might want one to fit into your strategies, and what to look out for if you do. Now, I guess I might open the floor to questions. If you haven't done so already, you can put them through the chat box or that control panel on the right of your screen. Okay. So one question there, can you issue different classes of shares? Now, I suppose very, very short answer is yes, you can, but the relevance or importance of issuing different classes of shares is that you can attach different rights to their shares. On the flip side, it does also mean that you come out of the potential tax concessions. So it may be something to really think about. You do, I guess, in terms of valuations, you do need to think about things like what rights are attached to their shares, because it can mean that those shares might not be worth as much as you think, meaning employees aren't as impacted as you might have thought they were. Another question there, how expensive are ESOPs to administer? Good question. Now, the cost of an ESOP isn't so much about administration, although admittedly there are things like, I guess, reporting or disclosure that you need to do, and you do need to factor in the cost of valuations at the start of the ESOP, as well as before you issue the shares, especially if you're issuing options. And that does factor into it. In terms of cost, it really depends on how much your accountant is going to charge you to help you prepare the valuations and the reporting statements. And I guess, but I'd imagine it's only a few $1,000s, not to put your accountant under the pump or anything. And then once again, it's a few thousand here or there just to set it up. Another question has come in, and I think this may be for Andrew. Any suggestions for strategies for giving loyalty bonuses? Consider at the 6-month review to give a 2% bonus and then a 5% bonus in a further 6 months.
Yeah, that's a good question. And I mean, that process sounds reasonable, and obviously you'd need to carefully draft the employment provision if it's in contract or policy to, I suppose, you're instilling loyalty there because there's basically the opportunity to get the 5% bonus at the 6-month mark. I suppose the question is, how does it continue into the future? Is there a discretion attached to that, and will that discretion then undermine, I suppose, the employee's confidence in the payment of that bonus? I suppose 2% at the 6-month mark and then 5% at the 6-month mark, so over 12 months. It's basically giving you a reward just for getting through probation. The general probation period is 6 months, and then reaching the 12 months. So that's a logical loyalty scheme, but I would then question the discretion attached to that and whether that would instill the confidence in the employees that it will continue into the future.
Okay, I don't think there's any more questions coming through at this stage. So I guess let's wrap it up. But if you do still have any questions, or if you don't think this is the appropriate forum, feel free to contact either Andrew or myself directly afterwards. Once you do leave the session, you will receive a short survey, and we do appreciate any feedback you have about today's session. You will also receive a follow-up email containing today's slides and a recording of the session. Now, on behalf of Buddy Perry, thank you for having us today, and hopefully you enjoy the rest of your day. Thank you.
Thank you, everyone.